workplace safety and work injury, organized by Law Society Pro Bono Services in collaboration with the National Trades Union Congress, also known as NTUC. I'm Qian Hui, your moderator for today. Just some housekeeping matters before we get started. Please don't take screenshots or share the materials here without the permission of the organizers. Please feel free to ask questions at any time during the webinar using the Q&A function, and we will do our best to address your questions during or at the end of the talk. Please note that our discussion and any materials provided are not intended to substitute or constitute professional legal advice, and you should consult a lawyer if you require specific legal advice for your matter. All right, with that done, let's get right into discussion. So now with work from home being the new norm and more freelance delivery riders now than ever, we find ourselves wondering how the concepts of workplace safety and work injuries have changed. We're very honored to have two distinguished speakers share more about this topic today. First, we have Mr. K. Anparasan. Anpa is the Managing Director of WhiteFern LLC. He brings with him more than 27 years of experience in the insurance and reinsurance market. Anpa, if I could invite you to turn on your camera, please. Hi, Anpa. So speaking alongside him is Mr. Patrick Tay. Patrick is the Assistant Secretary General of NTUC and Director of NTUC's Legal Services and Strategy Division. Anpa and Patrick. Hi. Anpa and Patrick, thank you both for joining us today.
Our pleasure.
So we'll start today's discussion with a brief sharing of the laws relating to workplace safety and work injuries by Anpa. After that, we'll move on to common case scenarios, which some of you may find yourselves in, and Patrick will join us then to share his practical insights while Anpa weighs in on the law. And we'll lastly end the webinar with a Q&A session where both Anpa and Patrick will aim to answer any queries you may have. So as mentioned earlier, please feel free to ask questions anytime during the webinar, even if it's before the Q&A session, and we'll do our best to address them. So without further ado, I'll pass the time to Anpa for him to share about the law on workplace safety and work injuries now. Anpa, please.
Thank you. Good evening, everybody. It's a pleasure to join in this seminar to share with you some of the legal thoughts covering issues. These are hot issues these days regarding work from home. There are some issues about gig economy, self-employed. And so it's going to be an interesting talk. And Patrick will join me in later. I think there are some practical aspects to what is happening out there, the new work environment. You all would have probably seen how this is being discussed in Parliament, and developments are on the way. Today, what I hope to share with you is this. Let me just talk about overview. I think it's good for you to know my roadmap, so it's easier for you all to follow my talk. I'm going to just start with what is the definition of a workplace. It's legal, it's very boring, but it's good to know what is the legal definition of a workplace, why it is important, because work from home, okay, is it defined under the workplace in the legal in the Act. Next, I will go into the legal definition of who is an employee. This is important because we have now the gig economy, self-employed people. So that's important. So hear me out. What is the difference in law between an employee and a self-employed person? Next, we'll talk about workplace accidents. What are workplace accidents? What is a workplace injury? Next, I'll talk about what are the employer's obligations and the employee's rights under the relevant acts, legal acts. Next, finally, I'll be talking about a bit more about insurance. What are the insurance available? Okay, without further ado, now that I've set up the roadmap, let's look at the next slide. Okay, as I mentioned, this is going to be a very dry slide because it's very legalistic. But let me just share with you what this means. Okay, originally, the Act was known as the Factories Act. So those days, the industrial days, people mostly were working from the factories. So that's why it was called the Factories Act. And then subsequently in 2006, this act, so this is what you all should be familiar with now, is called the Workplace Safety and Health Act. Okay, this replaced the Factories Act. And if you look at Section 5, subsection 1, the definition, legal definition, workplace means any premises where a person is at work or is to work for the time being works or customary works and includes a factory. So that's a legal definition. So because you will understand why this definition is important as I bring you through the slide. So just bear this in mind, this act called the Work Safety and Health Act and what it defines a workplace. Next slide, please. Traditionally, yes, a workplace is you go to an office, it's in an office building, industrial building, a school, okay, or those who are working in a retail shop, or those who are working. So this is a traditional workplace. Okay, of course, definitely factories are also included because factories are regarded as higher risk. So factory definition is there just for your knowledge. So this sets the tone for the next slide. This is the traditional workplace. Work from home. As Qian Hui mentioned, this is the topic that I wanted to take on and to explain to you all how in law work from home arrangement will affect your rights as an employee. Firstly, who is an employee? The Work Safety Health Act defines an employee as any person employed by an employer to do any work under a contract of service. Let me explain what's a contract of service. This is essentially your employment agreement, correct? Everybody would be governed by an employment agreement, either verbal or written, mostly written. The contract of service is where it says you work for your boss and defines your salary and your scope of works and all that. So it's called a contract of service. Just bear that in mind because the next slide I'll be talking about contract for service. So don't confuse. Employee are those who are under a contract of service. And it can be argued working from home is considered at work because section 4, subsection 1 of the Work Safety Health Act says this. In relation to an employee, all times when the employee is performing work in connection with any trade, business, profession, or undertaking carried on by his employer, wherever that work is carried out. In relation to a self-employed person, all times when the person is performing work as a self-employed person, wherever the work is carried out. And in any other case, all times when the person is performing work at the direction of the other person who engaged him, wherever the work is carried out. Okay, why this is very important is this. Because 4A doesn't say it must be an office or factory. It says it's in connection. If your boss tells you to do something, so long as it can be proven, is connected to your work. Example, he tells you, can you undertake this work? And even if you have to travel overseas for that piece of work, business meetings, because it's in connection with the trade, it's performing work. And at the direction, look at C, direction of the other person who engaged him wherever the work is carried out. So this definition alone is enough to satisfy all of you out there who are working from home and who are employees. You are well protected. Even if you work in a shared workspace like we work, yes, it is also considered at work. So this is the background to the act where you work from home, it's covered. Next. Okay, this is an important point because, as I mentioned earlier in my introduction, self-employed. I think a growing proportion of the workforce is now self-employed, either through the, you know about the platform, the gig economy, and those who are doing their own business. But there's a difference between an employee and self-employed, a big difference. Employee, I mentioned, is under a contract of service. Self-employed is defined as a person who works for gain or reward, otherwise than under a contract of service, whether or not employing others. Okay, simply put, if you don't have a employment contract of service, your contract for service. That means you are doing service for somebody else. Example, freelancers, you are doing service for Grab. Example, you're doing service for a company, they engage you to say, do pruning. Okay, they tell you, you're self-employed, can you come to my premises? Can you do pruning for my garden? So there are a lot of freelancers like this, or photographers. You know, there are many such freelancers around, and the freelancers are considered as self-employed people. And it can go on, private hire drivers, food delivery people, you know. So this is the definition of self-employed. It's important because the employees have protection under the Work Injury Act. I'll go on to the next slide. Yes, here you go. Remember earlier I talked about the Work Safety Health Act, WSHA. Now let's move on to another act. So I'm sharing this with you so that you all are familiar with your rights. And this is called the Work Injury Compensation Act 2019. Essentially, this act is to help the employees to recover compensation from their employers whenever there's an injury suffered arising out of in the course of their employment. Okay, very important for me to go through this particular section because when you get injured. Payment of compensation. Next word, keyword, employees. Remember, employees only get protection under WICA for now, under this act. Next keyword, please remember, injury. Next keyword, please remember, arising out of and in the course of their employment. So the question will arise. What about employees who are working from home? Remember, I talked about this earlier. So you must read this Work Injury Act with the WSHA. So if somebody is working from home at the instruction of his boss and he suffers an injury arising out of in the course of their employment, they will be covered under the Act. All right, next slide, please. Work from home, typically, whenever there's an injury, burden of proof. What is burden of proof? Burden of proof means you have to show that that particular injury you suffered, it arose whilst you were doing work at home. Evidence is required. There's a fine line, we all must agree, when you're at home especially. When you're performing work, or are you performing non-work activities at home? This is where it's a very gray area. I think Patrick and I will be discussing this during our panel discussion, so I will not go further except to say that please remember the Act, because anything that you do and you get injured, provided is arising out of and in the course of employment, that's where this comes about. Remember that. Is it a work-related injury when you trip over and sustain injuries while doing the following? Example, sometimes you walk from your work desk, the living room, you go to your paper, the printer in the paper, and you pick it up. Is considered, of course, work purposes because you are printing something. Running from printer back to work desk to do something urgent for work, you fall down? Yes, it is. Walking from work desk to toilet can be covered. Walking from work desk to kitchen to grab bottle of water from fridge, it can be argued. It's incidental to work. I must grab my bottle of water from my fridge. It can be argued it's lunchtime. Be that as it may, you are entitled during lunchtime to eat or go to the fridge to get something. Walking from the kitchen back to the work desk, yes, it can be argued. It is part of work. Walking from kitchen to toilet during lunchtime, yes, I will say it is incidental to work. tricky examples. What about if you suffer a heart attack? What if one unfortunately suffers a stroke whilst you're working from home? Big question mark. End of the day, back to my slides, it must be an injury arising out of and in the course of employment. So if it can be argued that you're doing something at work and you're on your computer and then there's a heart attack, you can argue it's because I'm doing work. But it's not that easy. Remember the word above my slide, burden of proof, evidence is required. Surely a doctor's report is required. Why did you get that heart attack? Why did you get that stroke? If the doctor is going to say, example, yes, this person suffered a stroke because of his uncontrolled diabetes, because of his hypertension, and because he failed to take my medication. So if the evidence is that this is because of your own doing, so to speak, unfortunately, the employer will argue, this has nothing to do with work. Why should I pay you? Okay, we'll discuss this further. Move on to the next slide, please. Okay, we were talking about the self-employed. Remember, I did say, as of now, under the Work Injury Compensation Act, they are not covered. Okay, it is very important now for the self-employed people who are moving around to take care of their own safety. Because even if they are working, literally they are working, correct? If they are delivering food or they are driving a taxi, if they get injured, unfortunate, they cannot make a claim under this act and say, I sustained injury at work. Why? Because they are not under the act for now. Then what do? They can only go, there's this thing called common law. Common law means you don't have the act, you have to sue somebody in court. So for example, there are case examples later, but I'll just give you a simple example. Let's say a Grab driver is now driving his Grab, and let's say another vehicle bangs into him and he gets serious injuries. Lucky for him, because he can actually sue the other driver's car, but the other driver's car insurance will come in, because if the other car was at fault, this Grab driver injuries, medical bills, so long as he was not at fault, he can actually look to the other insurer, the insurer of the other car, to pay for his medical bills, his injuries, his loss of earning. But he cannot go to his Grab and say, pay. They won't. Okay, but of course you can cover this through contract. I'll cover that in my other slides. So please remember, if you are self-employed, unfortunately the recourse if you suffer injury is against tort feasor. Tort feasor in law means the person is an individual who caused you to suffer an injury. Okay, let's move on. Injury, I've discussed this before. It includes injury to health, contraction of a disease, and the aggravation, accelerations, or recurrence of any bodily injury or disease. Injury of personal injury includes occupational disease as well, because there are people who are working in certain shipyards or whatever, asbestos exposure. So there are certain items, I shall not bore you, in the act itself where occupational disease, which are defined, can be covered as well. I mentioned to you the controversial items are going to be heart attack, stroke, acute blindness are all injury. At this time, I just want to give you an example so that in the context of injury, a heart attack. There's a famous case which I think it's, you can Google this. This happened a few years ago. Employee of a company was assigned by the company's boss to go to Bangkok to do a presentation for the company. And that employee took a flight, went to Bangkok, was in the hotel, and he went for dinner. He came back. Instead of sleeping, he was working on his computer. And then he had a heart attack. Unfortunately, he passed away. It brought up very interesting legal issues. Firstly, he passed away not in Singapore, in Bangkok. But remember, I told you earlier in the slides, so long as boss assigns you and you're doing work for the company, it can be anywhere. So the court said, yes, okay, it's covered. Next question, tricky question. How did the heart attack happen? It could be, you could have done something in Bangkok, we don't know. But thank God the computer was, they managed to look at evidence that he was actually literally doing work. There were slides he was preparing or something along those lines. So the court held that that injury was covered under the Work Injury Compensation Act. So the family passed on, the family got the benefits of the compensation. Okay, next I shall move on. Just to know your rights, okay, there are obligations of the employers. Again, this is covered under the Work Safety Health Act. So the duty is on them to ensure the safety and health of your employees at work. This section is important because now it's again in the panel discussion later with the rising pandemic, or rather endemic. This is a very particularly important section. And they have a duty, as far as practicable, to ensure safety and health of persons who may be affected by undertaking a work carried on in the workplace. Okay, move on to the next slide. Under the Act, again, the Work Safety Health Act, there are some measures that they have to take. What do they need to do? Provide and maintain a work environment which is safe, without risk to health, and adequate as regards facilities and arrangements for their welfare at work. And especially in respect of machinery, equipment, they need to be putting in safety mechanisms. And they also need to ensure that their employees are not exposed to hazards arising out of the arrangement, disposal, manipulation, transport in their workplace, near their workplace. So they need to basically make sure there's no hazard in the workplace. They need to also deal and develop procedures for dealing with emergencies that may arise at work. In this regard, very important for some of you to know, those of you who are working, let's say, for a company which provides transport. Typically, I can think of some industrial companies which are located very far away into us. They provide a company vehicle and transport the workers from the company back to a particular place, example, to the MRT station. There you are, taking the company operated, company provided vehicle on the way to the MRT station, you get into an accident. It could be also, as you are going up the vehicle, you fall down. It could be also when you are in the vehicle, there's an accident. Again, this is covered under the Act. So the protection for the employees when they are taking company provided transport. Next slide, please. Just give me a minute. Now, most important for all of you out there, what are your rights? Especially when you suffer an injury in the course of your employment. Good news is that under the work injury, you don't need to prove the employer is at fault. For example, you don't need to prove you didn't do this, you must show evidence. I know I said you must show evidence. That is, you need to show evidence if you are working from home and you are not performing work, or if there's an injury and the injury is attributed to something. Example, factory. The guy is in a factory and doing some work. For some reason, he wasn't even thinking, he puts his hand into the machine and his fingers get crushed. Employer cannot say, it's your fault. You weren't thinking, you weren't concentrating. I'm not going to pay you. No, under the work injury, it's called no fault. So it's good because the work injury protects, because all you need to show, number one, you're an employee. Number two, that work he was doing was in the course of the employment, and during work, he will get compensation. A lot of them may not be happy with the Work Injury Act because, as you all would know, I don't want to go into this. The limit under the Work Injury Act, every injury, there is a compensation amount. It's provided for in the Act. I don't need to go into it, but just give you an example. If it's just a finger, one small finger fracture, maybe there is a table, you probably get 5,000-6,000. Okay, that's all. And then if it's a leg fracture, you may get a bit more. If there's death, it's even more. So there is a limit. But a lot of times, some of the workers, let's say they get injured, they are entitled to sue the company and get a higher amount. This is called the common law approach. The common law approach means you don't go under the Act. I will now sue the employer under the common law. Employers are under the law required to take insurance. So even if the employer is don't have money, the employer's insurance would have to pay that compensation. Okay, but the difference is under common law. The employee, you need to prove that they didn't do A, they didn't do B, they didn't do C, they breached all this. That's why I suffered this injury. So you see the difference? In common law, you need to prove fault and negligence. Under work injury, you don't need to do that. So therefore, this is a protection afforded by the government under the Work Injury Act. It's a pros and cons. The pros is don't need to prove fault. It's a faster process. The con, disadvantage is the amount may not be as high if you go under the common law. Okay, so this is basic. I've just elaborated what I can under your rights. Next, self-employed rights. This is tricky. Again, this is a hot topic now. What is going to happen in the future? But for now, since the self-employed are not covered under the Work Injury Act, all I can tell you is this: protect your rights. Have a contract in place. Whoever engages you, I mean, I know it's difficult because if you're being engaged by a platform like Grab or Deliveroo, they have their own terms and conditions. But if you're a freelancer, somebody is engaging you to do works, have a contract. Make it clear from the outset your rights and responsibilities from the health and safety standpoint. Simple example would be if you are a freelancer and you are somebody engages you, the owner of a house, to come and do painting, you agree to do it, have something in place that, in case there's some hazards within the owner's house, what if you fall down, that he ought to compensate you. So, I mean, it's tricky, but that's the only way you can do it, protect your rights. If a freelancer gets injured while doing works, okay, and somebody causes that injury, okay, I gave you that example just now, another car banging into you, you need to prove the other person is at fault. then you can claim insurance against the other parties' insurers. Okay, so just bear this in mind. It's going to be very costly if you get into an accident if you are a self-employed person. What can you do? Next slide. Insurance. Okay, there are many types of insurance. One of the types of insurance is, the employers would have taken out, as I told you, is work injury compensation policy. The platforms that you are working for, okay, I've seen this, Grab, Deliveroo, they also have insurance in place. Okay, there are many words there, it's big words for you, but they have insurance in place at times to cover gig economy workers, medical bills, their medical hospitalization fees and whatnot. So it's important for you when you undertake a project or work, check this. Example I gave you earlier, this owner asking you to go into the house, do painting work. He could have insurance in place, public liability policy, meaning somebody goes into his house, trips and falls, that insurer will pay. So check this. It's very important to ask around whoever is assigning you work, what kind of policies you have in place. You can check around, we'll come to who you can seek advice from later. Are you protected? Next slide. If you're an individual, can't advise you more than to go and seek your insurance agent's advice on seeking your own medical insurance, your own personal accident insurance, your travel insurance, especially those who are on the move. Go and get adequate coverage. Motor insurance, Grab and Gojek, they have their own insurance. Make sure you check what is the coverage. There are many things to check. I am not going to confuse you. Excess, exclusion clauses, notification, all these are very important because you need to know in an event of accident what you need to do. So please familiarize yourself with the insurance that has been taken out by your platforms that you work for. Take your own insurance policies as well, because especially if you're on the move and you're getting into accidents, nothing like a peace of mind when you are out and about. Next slide, please. Yeah. Yes, it's arising from the last point. Basically, make sure that the other person, the tort fees, or again, the person who causes the injury, can actually take out insurance, and that insurance will pay if you get injured by their hands. Okay, I think this one I've covered. We can move on to the next slide. Okay, in a nutshell, this is going to be my last slide. So thank you for bearing with me. So I'll just go through this with you. Safety is of the utmost important. We all want to work for a living, but safety is important. So insurance may not be the be-all and the end-all. So just remember, if you really need to take action against the employer, whoever, evidence is important. You need to do proof that it was arising out of the accident. Don't take workplace safety for granted. You must be careful yourself. And especially now, in view of this work from home and this gig economy, there are many safety issues which we will be very happy to discuss during our panel discussion and also during our Q&A session. So what I will do now is to hand over to Qian Hui now. Thank you.
Thanks so much, Anpa. So that was a lot about the law, but I personally didn't find it dry or boring at all. But now that we're more aware of our legal rights and responsibilities, let's see how we can apply them to some of these common case scenarios. So let's invite Patrick back for these discussions. So for our first case scenario, with more of us staying home now and making use of food delivery services, some of us are also pivoting to this new freelance job. So let's find out about how our freelancers can protect themselves. So in this case, Adam is a freelance delivery bike rider working through a food delivery platform. And one day he had to wait a very long time for a particular cafe's food. And because of this wait, he had to rush to the customer's house to meet the estimated delivery time. And this caused him to collide into a pedestrian, who was an old lady. He collided into her with his bike. And this old lady hurt her spine, while Adam himself got some cuts and bruises. So, Patrick, perhaps could you share what should Adam do immediately after the accident? And maybe Anpa, you can also share about the legal rights of both parties. Do they have to pay for each other's medical bills, etc.?
Yeah, thanks, Qian Hui. And before Anpa goes into the deep legal stuff and explanations and the various scenarios, I thought just to share that in this case is as you can see, the hypothetical is someone a delivery rider using a bicycle. It could be an e-bike, it could be a bicycle. So take note, it's an e-bike or bicycle. So unlike whether a motorbike or a motor vehicle, where there's a mandatory requirement to have insurance. However, in most cases, in the NTUC and the labor movement, we have been working very, very closely with many freelance and self-employed workers. In particular, we have even formed an association called the National Delivery Champions, where we try to organize many of these food delivery as well as dispatch riders and drivers, and try to bring them together to resolve various issues. So this is one of those issues, because many of them may not be aware of what they are going into. Anpa shared earlier about contract for service, meaning most of them may be working in a contract for service arrangement, i.e. They may be working for some of the food delivery platforms or even dispatch or delivery platforms. So to take note, I know some of you are out there, some of our union members and some of you who are in this line of work or doing it either full-time or part-time or in a flexible way. Do take note that the terms and conditions of what the platform has with you. Read the fine print before you, I would say, sign. You don't sign, you actually go through your app and then you take the lozenges and then you send and submit and agree to all the terms and conditions. So be extra careful. Read the terms and conditions when you're taking on this assignment or this job. Particularly, I know many of you are doing this as well. And please take particular notice of the terms and conditions, because different platforms and different companies have different arrangements. So that's number one. Practically look at what is provided and not provided. Yeah, increasingly, insurance is something we are very concerned, not just personal health, but also personal safety. It's like this scenario where you hurt someone and you hurt yourself as well. Yeah. Fortunately, in Singapore, if you are warded in the hospital, we have a MediShield plan to cover most of us who are on a MediShield plan. However, sometimes it's just like in this case, cuts and bruises. When you see a general practitioner, those are not covered by MediShield, and unless there's some x-rays to be taken, otherwise you may not be able to even use your MediSave, and therefore it'll be out-of-pocket expenses. So take particular note. So there's injury to yourself, there's also injury to this third party, so to speak, the elderly lady. So as I alluded to earlier, unlike a motor car or motor vehicle or motorbike scenario, this is a delivery person on a bicycle or e-bike. Take note, but I emphasize e-bike because I know many of you are on e-bikes these days. Take note, there's no mandatory insurance via some compulsory third-party insurance. So I urge every one of you, if you are in this line of work, to take adequate insurance for yourself in terms of health and safety. At the same time, also for third party. There are available insurance plans for this. In fact, that's why I encourage all of you to be part of the labor movement or NTUC's freelance and self-employed team. Join us as members of this National Delivery Champions, because we actually have some schemes coming up or have actually rolled out some pilot programs to insure some of you for some of these, hopefully unintended kind of accidents where you might hurt someone or you might even cause property damage. I recall very vividly recently, one of my residents actually came to see me because he was doing delivery using his e-bike, and then lo and behold, as he was negotiating near the zebra crossing, his e-bike, the side handle, the right handle actually scratched the front bonnet of a luxury car, and he came to see me because the insurance company of the luxury car sent him a bill of about $5,000, basically for repairing the damage as well as respraying, etc. So you may think it's small matter, but sometimes it's just unfortunate it happens to you, and therefore the bill very much falls on your lap. So be extra careful. So therefore, if we are really doing this seriously and in a very very regular way, I really strongly encourage you to take some form of insurance. Like I said, it's available through some of our plans via NTUC Income, as well as there are available other avenues. I believe the food delivery platforms are also looking at this as well. So please take note of this. I can't emphasize more because my colleagues in the freelance and self-employed unit, including myself, are starting to see such cases. So and you read about it in newspapers as well. Yeah, sometimes pedestrians being hurt. Because I know many of you who are tuning in, you try to make as many orders as you can within a short period of time, especially dinner time, supper time, lunchtime. Usually you get a lot of orders start beeping on your app, and you try to do as many orders as you can because you have some KPIs as well as some targets to meet. At the same time, also sometimes you want to really do as many orders as you can within a short period of short window of 1-2 hours. So I understand that, but I do urge on a practical level, do be careful, particularly when you're negotiating. Singapore, not every part of Singapore is well lit, especially at night, and where the pavements and where the roads are a bit more wider. So you are negotiating all this. Please do it very, very carefully, because you may end up with liabilities which are quite insurmountable.
Thanks, Patrick. So I'm very glad to hear about this National Delivery Hero scheme, and insurance definitely does sound very important, especially as you said, there's still mandatory insurance for people using e-bikes and bicycles. But so apart from whether or not Adam has insurance, Anpa, could you share what about his legal liabilities? Would he have to pay for the old lady's medical bills, or is there anything else that he will have to pay for in this case, either from insurance or from himself?
Actually, before that, I want to share that what Patrick said. I didn't realize that there are avenues available to champion freelancers, in terms of insurance. So it's good. I think that emphasizes the point I mentioned earlier. Very good. I think I'm very happy to hear that. Because in this scenario, let's look at this scenario. Very interesting. Qian Hui, are you able to hear me?
Yes, I am.
Okay. So unfortunately, Adam now has to deal with two things. He is going to potentially face, like you said, a claim against him by the pedestrian. And number two, he's got his own medical bills to take care of. So let's talk about his potential claim by the pedestrian. Firstly, we need to establish how it happened, correct? Whose fault is it? So let's say if the pedestrian is the one who was absent-minded, who was on a handphone, and then collide into Adam, she cannot go and claim against it because she's at fault, correct? So in that scenario, Adam is lucky. In a sense, he cannot face a claim by the elderly lady for her medical bills or injury, because Adam will say, how was I at fault? But in the event, it was Adam due to the pressure of time, he's rushing, to take this order. That's what Patrick said, there's especially during the time the clock, the KPIs, he's rushing. He failed to see the elderly lady to collide into her. She has a medical bill, expensive medical bill. She got severe injuries. Surely she would go and see the lawyer. The lawyers will try their ways and means to see how to sue Adam. I've seen cases where if Adam is, let's say, a Grab delivery driver, they are trying, they'll name Adam and Grab in the action. And they'll try and say that Grab is vicariously, it's a legal term called vicarious liability, you are responsible for Adam. Grab is going to throw this legal argument back. No, remember the word contract of service. He's not my employee. How can I be responsible for a person who's a contract for service? So Grab will get out. Poor Adam is now all by himself. If he is not able to, if really the elderly ladies lawyers want to push this all the way through, just like Patrick's example just now, remember that delivery driver going to scratch that luxury car? Unfortunate, if you don't have insurance, you are responsible. But how far that lawyer will push it, we don't know. So in this case, okay, in Patrick's example, what he mentioned, we call the 5,000, he has to fork it out. Okay, fine. Maybe the driver says, I'm just going to pay 5,000 and borrow, I want to move on in my life. But here, this example is very unfortunate. The elderly lady's medical bills maybe comes up to 50,000. Her injuries, she can claim fracture of arm, 12,000. And she will say that, I suffered a lot of people saying this PTSD, post-traumatic stress disorder arising from this, make another claim. So this huge bill is against Adam. What will Adam do? I can't pay, I become a bankrupt. Unfortunate.
Yeah, so actually, Ampa brought up a very good point that, because he's quite experienced dealing with insurance claims and some of these injury claims. So actually it can amount to, a significant amount of money, because there's a whole list of claims from economic loss to, like he mentioned, mental distress and other claims. So there'll be a long list. So be mindful. But I thought also highlight that not just from a civil point of view, there may be criminal liability in this case, because you're knocking down an elderly person, and if he or she suffers quite bad injuries. We have read about it in newspapers, right? You saw some of these cases where some of these elderly were knocked down and suffered very bad deep gashes and broken arms and legs, and some even there are cases that cause death as well. So do take note that besides civil liability, there also may be criminal liabilities. Could be under the penal code for rash act or negligent act causing hurt, causing death, or even road traffic act offences, or even LTA, Land Transport Authority, may take certain forms of sanctions against or summons against you, particularly if you are, riding in the prohibited areas, and so therefore, please take note and be extra careful and guard yourselves and be safe. Yeah.
Okay.
You brought up a good point. Sorry, Chenny. Yes, I was looking
go
at
ahead.
civil liability. This is called criminal liability. So thank you, Patrick, for highlighting to our audience here. Carry on, Chenny.
So I was just thinking, it's quite interesting that you said that, because Adam is considered a freelancer, and so a self-employed person. So the food delivery platform wouldn't be liable, wouldn't have to pay for anything in this case. But then, does it have any sort of legal responsibility? The platform, does it have any sort of legal responsibilities to prevent such accidents from happening? Or if, let's say, Adam feels like actually it was the restaurant's fault because the restaurant made him wait for a very long time, and then the food delivery platform set a time for him to meet or something like that, is there any sort of claim he can go down there?
Unlikely.
Because he's considered a self-employed person.
That's right. So, but here you are saying is, even the restaurant, for example, I think one of the arguments you can make is, I'm rushing because this restaurant made me wait for some, let's say 30 minutes late, and I have to rush to the my delivery, the person who made the order. You can't make that argument. You were late, so that's why I rushed. So it's unfortunate you can't run that. What I said earlier also is, then you must have insurance in place, or you must have an agreement with the platform in place as well. In the event, I have a third-party claim, in this case, you will pay a certain amount, So maybe, I don't know how it works. You can maybe contribute certain portion of your income to them, tell them, you take an insurance, a group, we call it group insurance. It can be done. It's a forum which is open to the people out there to go and talk to the platforms out there. Will contribute something, go and take a group insurance for me in this sort of things. Yeah. The other point which I wanted to raise as well is Adam himself suffered, but as I said, he cannot go against his employer and tell Grab, hey, pay for me. They won't unless there is some contract is in place for such things or agreement. So unfortunately, this is the two scenarios I can see. Pedestrian's claim, his own claim. So, and Patrick put in the criminal liability angle as well.
Yeah, if I may just kind of like add icing to the last answer of this scenario would be well, the good news is if you've been watching the news and of course some of the discussions and including National Day rally, we talked about, a PM talked about it, that we are forming a work group looking at the issues and challenges faced by many of these freelancers and self-employed. So the good news is, in case you missed it, last week, Ministry of Manpower actually formed a work group. The labor movement is also represented in it, and together with some platform, not just platform, but some employers as well, and employer representatives, and of course there will be some consultation on the ground with the platform companies as well as with all of us, in this space, and they have actually looked at work injury and such insurance as one of the areas which they will delve into, because I think this is a growing challenge or issue, and with more people doing delivery, dispatch, and delivery, not just food, also with items that all of us buy from e-commerce. I know all of us buy lots of stuff from Lazada, Shopee, and Q10, and some of them actually ride bikes and e-bikes to deliver some of these to you. So we are looking at this, and you would expect to hear some positive news after a series of consultations in the next year or so, and also with the platform companies. I think the platform companies, I know, are also trying to find a way to provide some coverage in an incremental and of course in a graduated way, because as you know, the amount of income per delivery is not a lot, so they are trying to find a way to sort of like co-pay or co-fund. They've done it for the private hire vehicle drivers, but like I said, this is one important space we need to spend some time in. So that's a bit of a good news, and like I said, but till then, until some policies or even law sets in place, I think it's important for all of you to safeguard yourselves and be safe, extremely safe.
And on a similar note, talking about protecting yourself before these new laws or new policies come in place. So what are the practical steps that Adam should take immediately after the accident then? So for example, if he wishes to claim from his own insurance, or maybe if he feels like it was the old lady's fault, it wasn't his fault, what are the practical steps he should take to protect himself in the event that the old lady does claim from him, or in the event that he wishes to claim from his own insurance?
Maybe I'll jump in first before Patrick. Essentially, preserving evidence is very important. I mean, firstly, he's injured, I'm not sure, but luckily it's cuts and bruises. So if he's sensible and he's able to react, firstly, obviously in this modern day, pictures, the impact, where it was, the elderly lady was injured, where her injury was. And then if there are people, passerbys around, quickly, try and obtain, their particulars, and say, can you volunteer to be a witness if there's a case against me? Those are the practical things they can do. Another thing is, please look around you, and if you see like a CCTV, or nowadays our government, we have a lot of LTA, cameras around and all that. Just take pictures of your surroundings, so that you can later write to LTA. Sometimes they do provide footage and all that. So of course the lawyers will be advising Adam what needs to be done. So preserving evidence if he is in a state of mind is very important. Patrick, anything?
I think Anpa covered most of it, but I said he mentioned preserving evidence, take pictures, and if you ever hit someone or get into some of these unfortunate incidents, please don't rush or run away from it. I think important to take note of that, because it will be more aggravating circumstances if you abandon your bike and run off, or so just handle it calmly, with a cool head, and try to manage the incident carefully.
Okay, thanks so much. So I'll just sum up what we've taken away from this case scenario. So essentially, you should always read the contract you have with the platform. You should definitely get insurance if you haven't yet as a freelancer. You should preserve evidence if you are in this situation, and you should definitely look out for the policies coming up. Okay, so thanks very much. So for office workers like myself, my concerns are very different from a delivery rider's. So we're moving on to our second case scenario now. With work from home being the new norm, the boundaries are understandably blurred. Our offices are now at home, where we also eat, rest, and play. So let's take a look at this case scenario here. So Jane is an office worker who has to take care of her young daughter while working from home. Her daughter also needs to do home-based learning, but her daughter doesn't know how to independently use a computer. So Jane ends up being very stressed from having to juggle both her caregiver and her career responsibilities. At the same time, both of them don't have dedicated workspaces. They can only share one laptop in the living room, which doesn't have proper work desks and chairs. So in addition to her stress, she's also been getting severe backache from sitting on the sofa, not having a proper work environment. So I think our audience also have similar questions. I've seen some questions coming in asking about, if my work desk is not ergonomic, I have headache and backaches, can I claim, from under WICA then? Maybe Anpa, you could let us know.
Thank you, Qian Hui. I did cover this in one of my slides, but it's time for me to elaborate. This is a very good example. So Jane's example. Okay, two things can happen. Of course, she's got now severe backache and increasing stress. Remember, Work Injury Compensation Act. Try that first. If I'm Jane, I'll go to my bosses. I will say I'm going to claim under the Work Injury Compensation Act. Jane clearly falls under the definition of an employee, correct? The boss tells her, go and work from home. Number two, because the boss tells her to work from home and she's doing work, and in the course of doing work, she's now saying, I got severe back. Okay, firstly, this is very tricky because it's severe backache. The two elements here, I'll take one by one. Let me take severe backache first. If let's say Jane already got a pre-existing, meaning a lot of people have got back issues already, we call it the L5, S1, the slip disc. She already got this, and then she exerts herself. Maybe we don't know. Maybe she's doing yoga. Maybe she's doing too much running. So it's quite going to be a bit tricky for her to argue employer is the cause of the severe backache. So this is where I'm saying, I've seen cases that employers, insurers may contest. I'm not saying all insurers. Some insurers may say, okay, the MOM will make an assessment because let me tell you how the procedure works. So Jane will now lodge a report with the boss saying, boss, severe backache. Goes to see a doctor, doctor certifies yes, backache. Now she lodges a work injury claim. MOM will investigate. Employer has to give their report. Employer will say she's been working from home for over a year, nothing to do with us or whatever. MOM will then investigate. MOM will then decide. Maybe the MOM will say, yes, we have heard the version of the employer, we've heard the version. Maybe MOM will say, not work related. Then she got to go and get a lawyer to fight it. So evidence, back to evidence, she needs to show medical evidence. It's got to do with the employer failing to provide an ergonomic check, a proper working environment. So it's going to be a question of evidence. So backache is a big question mark. Increasing stress. Stress technically is not injury. Remember, I read out the definition of injury. Heart attack has been argued, yes. Stroke maybe, but stress is going to be difficult to say it was an injury. So therefore, it's going to be tricky in this case, my honest opinion, for Jane to make a claim under WICA because she needs the medical evidence to back her up. But if the scenario is such, as I mentioned to you, she was going to grab water. She walks from a work desk and she walks towards the kitchen. And let's say what she has, because of the stress, she suddenly has a headache. And because of the headache, she falls down. Her head hits the floor. She goes into, I've seen this case actually, there's some such examples. This would hits her head, falls down, brought to the ambulance. I know she suffers a head injury and they say, I know she goes into stroke. This example, I would argue, hey, she suffered a headache, and it's because she was working, it's in the course of employment. And this stroke, which arises because of the headache and the stress, then it is arguable. This is a case which can be argued it is in the course of employment. You correlate because she's doing work, she's going out to get water, and she falls down because of the headache. And the doctor says the headache is because of stress from the work, and then she goes into she suffers a stroke. I'm digressing from this example. So there are scenarios, there are controversial topics surrounding this. Over to Patrick.
Yeah, I was actively trying to answer some of the questions which many of our audience have been starting to file very actively. But just to add on to what Anpar shared earlier, working from home is the so-called next normal. I think many of us, including myself, in the last 18 months have gotten used to having to work from home. Particularly many of our professionals, managers, executives, who are white-collar workers and who are office workers, are able and can work from home. And as we move into the next normal, I think it may well be an arrangement where some companies go completely work from home, some companies do a hybrid of it, or some companies require you to be in office, particularly for frontline workers where you are unable to deliver the service or the kind of work if you are from home. So those who are able to work from home, I think some companies have started to roll out new policies and updated policies. But this is a very important point because I've actually raised this question in Parliament to the Ministry of Manpower on, with work from home, how do you classify, and are there cases of work injury for those who are working from home? It could be a person on his laptop, like some of us, doing work and then walking to the toilet and then slip and fall. So there are various circumstances, depending on circumstances. And the answer I got in Parliament Live a couple of months back was that there have already been a few cases that have been filed by employees who are working from home under WICA. So some of these cases are being investigated. I'm also trying to get some answers and updates so that we can throw more light on this. But otherwise, it would be pretty circumstantial and depending on the evidence collated and also the exact circumstances that led to the injury. Yeah, it could be maybe perhaps excessive use of laptop, and then the scenario says severe backache and increasing. I don't rule that out being one of the circumstances that there may be tantamount to work injury. So we don't rule that out because it's definitely a new area. Yeah, something which all of us are including the medical practitioners and of course those who do the assessment whether the backache or the back injury or the slip disc or whatever was a result, or degenerated disc was a result of excessive sitting, excessive being in front of the laptop, computer or device, and etc. So I think a few practical points. Firstly is of course, as an employee, please do your part. I know companies, some very enlightened and progressive companies have started to encourage. I provided a whole suite of gadgets and even subsidized or given flexible benefits for workers and employees to purchase things that will be helpful. Simple things like a table lamp, that's properly so that your working area is properly lit. Simple things like a reasonably comfortable chair so that if you sit on it through a prolonged period of time, you don't get some of the aches and pains that some of us get. So I think some of these things are being already rolled out by some employers. I know of them personally, and through flexible benefits or providing all this gear. Of course, there's a whole range of some of these products. It can be as cheap as less than $100, but you can go into the thousands. Depending on, I don't mention brands, but I know I see from some of the Zoom videos, some of the high-end brands that many people are now into. They're using gaming chairs for their Zoom sessions as well in their meetings. So like I said, practically that's what employers should do. Employees should do your part as well. So that and I am increasingly seeing people doing it. Like you don't sit in a prolonged period in the same spot all the time. Maybe you move around, you try to exercise a bit, because I think the onus is on you as well to take short breaks. I'm not saying very, very long breaks all the time, but take short breaks, have a drink, go to the toilet and stuff like that. So I say it's important. So do take note of those. And I'll be more than happy to update once we get some sensing on the outcomes of some of these work injuries and whether they are tantamount to work injury compensation, particularly if the employee was injured while working from home. Yeah.
Patrick, if I just jump in, from employers, nothing to do with lawyer. I mean, I'm an employer and I have implemented care packages. We call it care package, So you're absolutely right. I think that's the least we could do. They are working from home, ergonomic chairs. They're reasonably priced, lamps, give them a conducive environment. From an employer's point of view, what Patrick said is, I would urge whoever employer, care package. I think that's something which will go a long way.
Yeah, because if you recall, there's there's an implied duty in law for employers to provide a safe and healthy workplace for employees. So if let's say your company is implementing full work from home, so you should have the relevant programs and policies to address some of these important points. Yeah, later probably the third scenario will talk a bit more about COVID-19, but otherwise these are some of the practical points, both from an employee's point of view as well as employer's point of view. And I've attempted to answer some of the questions that were posed, so keep them coming. We'll try to answer them during the Q&A as well as and when we see it, and then it can be easily addressed.
Thanks, Patrick and Anpa. So I found some of the points you raised very interesting. And I guess I want to expand on some of them. So you were mentioning that, like Anpa, you said that you provide your employees with care packages, but does your employer's workplace safety obligations mean that your employees can also ask for equipment such as an office laptop and even an ergonomic chair? Is that within their rights?
Yeah, this is arguable. I think what Patrick said is important. I think there is a duty on the part of the employer to provide a safe environment. Okay, if your employee is going to ask you, give me a secret lab chair, I'm going to say no. Correct? I mean, you need to provide what is reasonable. Okay, reasonable in my opinion. I mean, opinions differ. Okay, you make sure ergonomic chair, a lamp, a simple thing like that. A good laptop. I think the basic safety ought to be there. There are implied duty, like what Patrick said.
Okay. And you also mentioned about how if you walk to get a glass of water, that could potentially be construed as being a workplace injury. But I mean, this is also straying from the case scenario. But I mean, I'm just wondering about the burden of proof, right? How can she prove that her injury is a workplace injury? And her employer could just say that you could have just slipped on something totally unrelated to work, your daughter's toy lying around the floor, for example. How do you prove that it's a workplace injury, I guess? Do you just go to the doctor and immediately after the incident?
Very good point, Chinvi. Recall I mentioned, if you go under the Work Injury Compensation Act, the burden is not so much on the worker. Immediately you show you are working, and then you slip and fall, you go to the doctor and say that, I was working and I was walking to the kitchen to get something and I trip and fall. Yes, so on paper, immediately it's considered work injury. Okay, you got a doctor's rate. The onus then falls on the employer. Correct? The employer now needs to come and argue. Okay, you didn't. So how are they going to get evidence? But so basically, that's why the work injury is a very good protection given by the government. It's a no fault scheme. So Patrick mentioned he's brought up these examples in the parliament because these are interesting developments. Because if you're in a workplace, it's easy because your colleagues, you can get evidence, your colleagues saw you falling down, tripping and all that, right? But here you are at home, that is the thing. On first blush, I will say, yes, it's work injury. But employer, how is he going to show evidence? that, that it was let's say, for example, Jane's daughter's toy. It's going to be tricky for them because onus is on the employer to show otherwise. So the employee, what he can do, like Jane, quickly go and see the doctor, give her version, and all that. Good enough, yeah. But if she goes and be honest and say, yes, I was walking and I slipped and fell on my daughter's toy, she left it, I mean, too bad, it's...
I see. Okay, so then we have a related question from the audience. So you said that WICA is a no-fault system. So what if an employee wanted to kind of try his luck and go for both WICA and common law? Can he do that at the same time?
No, the law is very clear. Our government catered for that. If you're going under WICA, you go under WICA. If you want to go under common law, you must withdraw your WICA and lodge a withdrawal, and then you go for common law. You can't have your cake and eat it too.
Okay, that makes sense. So expanding on this case scenario, in this case, Jane was suffering from increasing stress. But what happens then if she actually starts developing some sort of psychological disorders, or maybe she starts suffering from anxiety attacks or depression because she has to juggle both these caregiver and career responsibility roles? Can that then be considered a workplace injury, and can she be compensated for it?
It's a developing question. I mean, based on the traditional definition of injury read out to you, is usually injured, you fracture your arm, fracture your leg, fracture your finger. It has developed now to take care of heart attacks, stroke, psychiatric injury like depression, anxiety. My own view is that our legislation now has not catered for that, but I'm pretty sure Mr. Patrick Tay, and his colleagues will be looking into that, because even yesterday I heard in the news, teachers are suffering from stress, so it is time to argue, and make some changes to add psychiatric illness. For now, my own view is it's going to be very challenging to argue it's work injury.
Thank you. Okay, so one last question on this case scenario before we move on to the last one with the last 15 to 20 minutes we have. So we have an interesting question from the audience. He's asking, what happens if your employer is asking you to do work outside of working hours? Because now with work from home, I guess we have a lot more flexibility in timing. Our hours are not as structured. So if you have an injury outside your official working hours, can you be covered under WICA?
Good point, because end of the day, remember, it doesn't say what are the working hours. It all says that if it is in the course, one of the slides, I don't want to go back to the slide, but it
during the course.
Yeah, correct. So long as arising out of in the course of employment. That's all you need to prove. So boss asks you to do something, you do something. It could be midnight, it could be weekend. So long as you can show it's arising out of in the course of employment, you are covered under WICA.
Interesting. All right. Thank you so much. So now let's move on to our third case scenario, and let's flip the situation around. So what if an office worker was made to return to the office instead, even though working from home is still encouraged? So in this case, Emily, like Jane, she's also an office worker, but her boss asked her to continue working from the office instead, saying that the work requires her to be physically present. So while Emily doesn't agree with what her boss is saying, she feels like she doesn't have a choice. So she's working in the office 5 days a week. And one day she started having, flu-like symptoms. She visited a doctor, was issued 5 days MC, and subsequently it turned out that she contracted COVID-19 from her workplace. She was unvaccinated because of her personal beliefs, and she had to be sent to the ICU for critical care. Is this then considered a workplace injury, and can she claim medical expenses from her employer?
Okay, firstly, evidence. She needs to prove that the COVID-19 was contracted at the workplace, the exposure was at the workplace. So that's something, because in this day and age, people move from point to point, right? So you need to have evidence. For example, I think clear cut, there was an exposure. That day she came to office, there was this person who was already having COVID-19 symptoms, and the boss made both of them sit next to each other. So again, back to evidence, okay, correct, she needs to prove. So long as the evidence is there, clearly, okay, she can make a claim. But again, back to the issue of, COVID-19 being a new, pandemic since 18 months or whatsoever, medical expenses would be covered. I think here, one of the things is, what do you suffer as a result of COVID-19? Obviously, like you said, hospitalized in ICU, medical bills and all that. Clearly, in this case, employers, insurers cannot even say anything. So long as you prove with exposure because of workplace COVID-19, pay for the medical bills. But other than that, in this case, what is it that you can claim? I can't think of anything else. If there's loss of earnings arising from that, again, the employer ought to cover. Medical bills, they will cover. So this is something which I think in the going trend, which especially when boss is asking to come, and the trend is try not to work in the office if it's not absolutely essential. So the answer to this scenario is yes, employer will be responsible for the medical bills.
Yeah, I've also Anpa also attached the link in the chat. It's on the MOM website. I asked the same question as well. And so whether you can claim WICA compensation for COVID-19 infection. So the answer is what Anpa already pointed is that COVID-19 infection is compensable under the WICA if you contracted COVID-19 from exposure due to work. And then for those of you who are employers out there, you can actually claim reimbursement from your WICA or work injury compensation insurers. Yeah.
Thanks, Patrick, for reminding me. So there is a QR code on the screen. You can scan it to get our handouts for this webinar. Yeah. So does it matter that Emily, in this case, she was not vaccinated because of some personal beliefs that she has? Can her employer then refuse to reimburse a medical fee, saying that you wouldn't have contracted COVID-19 if you were vaccinated? Can they do that?
No, I don't think so.
Yeah.
Okay.
No, that's not a legal argument here. I'm just trying to think ahead. If let's say now the government mandates and legislates, okay, at some point in time, if they say mandated, then an argument could be made at that point in time. But for now, no, you can't run that argument.
Yeah, but just to let everyone know, I think as Qian Hui mentioned earlier, there's a QR code for some handouts. And in the handouts, we have included some of the tripartite advisories. In fact, in the last 18 months, I've lost count the number of advisories we have come out at a tripartite level. And one of those addresses this point on COVID-19 and whether you're vaccinated or not, or whether you voluntarily choose not to or involuntarily unable to be vaccinated. So take note, both employees and employers. I think for those who choose not to, because although it's available and they are medically able to, there may be some provisions for by employers to do redeployment if, for example, if it's essential service and you may be posing a risk to others within your working workplace. However, it's also stated in advisory quite clearly that employers should not dismiss a person just because he refused to take the vaccination. So just take note of some of these advisories. It will be useful and instructive. The ones that we have attached for the handout are quite contemporaneous and up to date. You can refer to that. And also to add on, I know some of the HR leads as well as employers may be tuning in. Take note of some of the advisories that are coming out because they really come out on the fly. Each time there's the multi-ministerial task force briefing, there may be advisories. For example, like last Thursday or Friday, there were some advisories coming out on the amount of time that employees should stay away from work and when they can come back, and also how are they classified, whether they're in the same office and the whole office goes gets a kind of like a leave of absence, or is it just a small part of the office? These are being articulated in some of these advisories that are coming out. So we provided the links, we have provided the pages, and they are all quite easily accessible. And like I said, I'm not 100% familiar with every single one of them off my fingertips. We know the general areas, but therefore it's important and incumbent to everyone, particularly those who are doing operations and HR in their workplaces, to take note of some of the advisories, because some of them are mandated at workplaces, and some of them are to help you to ensure that you have a safe work environment for everyone in your company.
Thanks, Patrick. Yes, do download the resources. They're very practical. We have a question from the audience, which I think is very practical as well. So he's asking that if, let's say, you sustain a workplace injury at work, so maybe in this case, you could be diagnosed with COVID and it's considered a workplace injury, but you have run out of medical leave for some reason. So for example, maybe you need to be hospitalized for more than 60 days, or maybe you run out of 14 days MC, etc. What happens then? Does this mean that the employee needs to go on unpaid leave or take annual leave, etc.?
Yeah, so there's actually a tripartite advisory on this, specific, exactly on point. The default setting now is in the advisory is that we encourage employers to deduct from the hospitalization leave instead of the other kind of leave provisions, such as compulsory annual leave or no pay leave, etc. So as you know, we have 60 days of hospitalization leave as provided in the Employment Act, and therefore it's incumbent on employers to use hospitalization leave for purposes of COVID-related kind of illness and sicknesses. However, there may be instances where the leave is fully consumed for one reason or another, because it may be not just because of COVID, but other illnesses. Therefore, employers are encouraged to be compassionate when it comes to such exceptions and exceptional situations, so that because sometimes it's through no fault of the person that he gets COVID-19. I mean, it's unfortunate sometimes because he handles a lot of customer interfacing, frontline workers, and therefore, it's a very we try to have a very, very amicable outcome and resolution for some of these well, I would say disputes over leave.
Thanks, Patrick. Okay, so thanks very much for sharing your thoughts and very practical advice on these case scenarios. So with our last 5 to 10 minutes, let's now highlight some avenues of help and remedies that our audience can have if they find themselves in these sort of unfortunate situations. So maybe, Anpa, maybe you can start with some sort of legal remedies, and then Patrick, you can move on to some immediate practical avenues of help that people can turn to.
Cherry, maybe you can show the next slide. Yes, yes. The legal recourse is obviously Ministry of Manpower. That's something which, of course, when it relates to work injury, as I told you, they are the ones who are administering the Work Injury Compensation Act. So, as I mentioned to you, if there's any doubt or any issues, go to MOM, because the Act is governed or rather handled by Ministry of Manpower. WICA, so this is interrelated. Work Injury Compensation Act, Ministry of Manpower has, as I said, overview of this, and they are the ones who will be dealing with how to resolve it. Common law, I mentioned to you, is available to anyone out there who gets injured, and if you feel that injury is caused by someone else, we call it tortfeasor. It could be your employer, it could be your fellow worker who did something to you, punched you, or you were out there, somebody bangs into you. So long as somebody else causes injury to you and you feel it's their fault, you can go under common law. But remember, I told you, you need to prove that person was at fault. And as I mentioned, damages are higher. So that's why a lot of people go under WICA, because it's straightforward, streamlined, effective, and you get compensation. So from a legal point of view, these are the 3 avenues you can go to, and your lawyers will be advising you which is the easiest and which is the fastest and which is reasonable.
Yeah, maybe Qian Hui, I will add on the previous slide. Yeah, so these are some of the other dispute resolution routes that you can do. Well, some we call it alternative dispute resolution, but the NTUC and the labour movement actually looks out for our workers. And in particular, many of our unionized companies, we have collective agreements, we have grievance procedures, and also issues. Myself, I head up the legal function in NTUC, and we do support all our affiliated unions across Singapore. So if you're a union member and a unionized company, do look out for your union leader or even contact NTUC, and we can help you and assist you and support you in that journey. Even for WICA claims, if you do have any questions, we also run, as part of this partnership with the LawWorks, partnership with Law Society Pro Bono Services Office, also run a monthly legal clinic. You can also seek consultation there for advice. Yeah, but at the same time, also for unionized companies, most of the time, if a worker or particularly a union member does face issues at the workplace for a variety of reasons, it could be the workplace is unsafe, you feel that it's unsafe, or the company failed to implement safe management measures, just approach us, and we will do the needful to touch base with the relevant agencies and authorities, because this time for COVID-19 is a multi-agency, multi-ministry kind of approach to resolving some of these issues, including, like, you're organizing big meetings, you go to a different agency, and then sometimes safe management ambassadors do come, or inspectors do come by your workplaces. Yeah, NTUC is not spared. The Ministry of Manpower also pops by our office and ambushes us to make sure that we have implemented our safe management measures, etc. So like I said, these are some of the available go-to places. It's all one stop, over and above what Anpar shared earlier about the legal routes, such as through Ministry of Manpower, through him and the legal fraternity through a civil action, or through the various statutory protections that are provided by each and every one of you. I can't emphasize more that actually some of these available resources as well, not just MOM website, Law Society PBSO websites, as well as the NTUC website, has a whole plethora and spectrum of resources, including FAQs for you to, that's why I've been assisting by routing you and answering some of the questions live with some of the FAQs that are available. So, navigate those pages. It's all available. Most of the questions and answers are available online, but if you have very specific, a bit more complex, a bit more legal issues, feel free to pop in. Particularly if you're a unit member, you can come by our LawWorks legal clinics, which is organized monthly in partnership with LSPBS for our unit members. So you get a business class treatment when you're a unit member. But otherwise, if you're not and you really need advice, depending on which part of Singapore you are in, PBSO also runs a community legal clinics which you can have access to.
Thanks so much, Patrick and Anpa. So maybe we can move on quickly to the last section, the Q&A section. So we have already covered most of the questions during the case scenario discussions. But I just wanted to highlight again that, please do download our handouts using the QR code there. Like what Patrick was saying, many of our resources are there. Just one very, very quick question before we close the session. Are there any exceptions to WICA? So for example, is anyone barred from claiming from WICA, for example, if they are earning above a certain amount of salary, or if they're working in certain areas such as like a domestic helper or public officers, etc.?
Good point, Qian Hui. Because initially the history of work injury, initially they only said, up to a certain amount, I can't recall, 1,006 or 1,008 only, or if you want to go above that limit, you must be a manual worker. And then our economy changed, our government realized there are office workers around. So in a sense, later amendments were made to include office workers, but it excludes management. Of course, it excludes domestic workers.
I see. Thanks so much, Anpa. Okay, so we unfortunately are not able to cover all the questions, but I think we've covered most of the very pertinent ones. And I mean, we're like a broken record, but do download our handouts because I think a lot of the answers can be found there. So we now unfortunately have to bring our session to a close because it's now 8 p.m. We hope you found our webinar on workplace safety and work injury useful. So once you leave today's webinar, you'll receive a notification for a survey, and we will appreciate your feedback on today's session because it will help us make future webinars a lot more relevant and useful to you. So thank you very much, Anpa and Patrick, for spending the evening with us. And on behalf of Law Society Pro Bono Services, thank you everyone for joining us today.
Thank you for the opportunity.
Thanks.
Goodbye, everybody. Thank you. Bye-bye.
Bye.
Take care.